Mr. President, I want to take the floor to talk about these critical nominations that the Senate's currently considering. In all of the talk about these nominations, about the politics of recess appointments and everything, one thing that's been missing is a real consideration of who are these people? Let's bring it down to the personal. Who are these people? What have they done? What could they do to serve our country? We seem to have forgotten in all of this chaff that's out there and all the arguments going on as to what we're supposed to be doing to fulfill our constitutional responsibility to advise and consent to presidential nominations. As I understand it, we're supposed to look at the qualifications of the candidates, determine if they're fit to serve. Beyond that, that's it. Well, the answer with all of the nominees before us is an unqualified yes. They are qualified and they are fit to serve, and the president should be allowed to put together his team. That should be the end of our task. We should confirm them all today or tomorrow, I guess, when they come up, and move on to the many other important issues facing this body. I'm going to talk in a little bit about the whole filibuster issue itself, but first I just want to talk a little bit about one of the first of the nominees that's up, and that's the president's choice to be our Secretary of Labor, Tom Perez. Without question, Tom Perez has the knowledge and experience needed to guide the Department of Labor, one of our key cabinet posts. Through his professional experiences, especially his work as Secretary of the Maryland Department of Labor, Licensing and Regulation. Yes, he was basically the Secretary of Labor for the state of Maryland. And he developed a very strong policy expertise about the many issues that confront American workers and businesses. He spearheaded major initiatives on potentially controversial issues, such as unemployment insurance reform, worker misclassification, while finding common ground between workers and employers to build sensible, common-sense solutions. It won him the support of business community and worker advocates alike. To quote from the endorsement letter of the Maryland Chamber of Commerce, quote, "Mr. Perez proved himself to be a pragmatic public official who was willing to bring differing voices together. The Maryland Chamber had the opportunity to work with Mr. Perez on an array of issues of importance to employers in Maryland, from unemployment and workforce development to the housing and foreclosure crisis. Despite differences of opinion, Mr. Perez was always willing to allow all parties to be heard, and we found him to be fair and collaborative. I believe that our experiences with him here in Maryland bode well for the nation," end quote, Maryland Chamber of Commerce. Mr. President, Tom Perez has dedicated his professional life to making sure that every American has fair opportunity to pursue the American dream. Most recently, as the Assistant Attorney General for Civil Rights at the Department of Justice, he has been a voice for the most vulnerable, and he has reinvigorated the enforcement of some of our most critical civil rights laws. He's helped more Americans achieve the dream of home ownership through his unprecedented efforts to prevent residential lending discrimination. He has stepped up the Department of Justice efforts to protect the employment rights of service members so that our men and women in uniform can return to their jobs and support their families after serving their country. As the Senate author of the Americans with Disabilities Act, I'm particularly pleased with Mr. Perez's long history of strong leadership on disability rights issues. While at the Department of Justice, he has helped ensure that people with disabilities have the choice to live in their own homes and communities rather than only in institutional settings, and to receive the supports and services to make this independent living possible. Like any leader whose career has involved passionate and visionary work for justice, Tom Perez's career has been one of making difficult decisions, management challenges. He's been the target of a lot of accusations and mudslinging and misperceptions. But we have looked, and I have looked carefully into his background and record of service. I can assure my colleagues that Tom Perez has the strongest possible record of professional integrity, and any allegations to the contrary are totally unfounded. Now, again, Mr. Perez appeared before our committee, was willing to answer any and all questions. Those that were at the committee, those that were submitted letter, he's answered more than 200 written questions. He made himself available to any senator who wanted to meet with him. So he has been most accommodating. And I can say that they have provided all the access, the administration has provided all the access that people have wanted to his personal emails. In fact, this administration, I can say from my experience over the last 29 years, has gone further in providing access to even personal materials of Tom Perez than any president has ever done before, any administration has ever done before. So again, he's been thoroughly vetted. He has the character, integrity, and expertise to lead this cabinet and the Senate. And the Senate should vote on this. Now, when I say the Senate should vote on it, we should vote on it with a majority vote. But no. Mr. Perez has been filibustered and held up to a 60-vote threshold. Now, we know that Mr. Perez has well over 50 votes, the majority, but because my friends on the Republican side are stonewalling this, he may not have 60 votes. But why should it take 60 votes, I ask? Why shouldn't it be a majority vote up or down? Now, the same is true for our nominees for the National Labor Relations Board. Again, these are three exceptionally well-qualified candidates. Mark Pierce has been a board member since 2010, chairman since 2011. He was previously a union-side attorney in private practice, before that a career attorney at the National Labor Relations Board. Richard Griffin is former general counsel of the Operating Engineers Union, and again, a former career attorney at the NLRB. Sharon Block served as Deputy Assistant Secretary for Congressional Affairs at the U.S. Department of Labor, and before that was on our Help Committee. She was the senior counsel for Chairman Kennedy when Senator Kennedy was chairman of our committee. And again, she's a 10-year veteran of the NLRB. Again, I've yet to hear one senator question their qualifications. Indeed, even the ranking member on the Help Committee conceded at their hearing that these candidates are exceptionally well qualified, and that he admired their qualifications and their distinguished backgrounds. Now, they've been thoroughly vetted. They've met with any senator who asked. They've answered more than 100 written questions each. They've come before our committee in a public hearing, not typical for all NLRB nominees, I might say. They produced every document requested, answer every question they've been asked. So again, if we concede that they're all exceptionally well qualified, thoroughly vetted, why can't we vote on them? Up or down? Majority vote. Again, some time ago, my friend Senator Graham, when speaking about the Senate's role in the nominations process, said, quote, "Our job, as I see it, is not to say what we would do if we were president. Our job, as the Constitution lays out for us, is to advise and consent by a majority vote, to make sure the president is not sending over their brother-in-law or sister-in-law or other unqualified people," end quote. So no one on these lists is anyone's brother-in-law or sister-in-law, I might add, and everyone is exceptionally well qualified. Again, if we're doing our constitutional duty, we would confirm all of these nominees today and nominees tomorrow and move on to our legislative work. So why aren't we doing that? Well, because my friends on the Republican side are hijacking these nominations and this nomination process to try to make changes to laws they know they could not change through regular order. So a single senator, a lot of times, or a handful of senators might hold up a nominee, not because the nominee is not qualified, but because they want some changes made someplace else that they don't feel they can get through the regular order of business in the Congress. Well, for example, my friends on the Republican side, they don't like the National Labor Relations Board. So what do? They can't repeal it, so they make it inoperable. Make it inoperable by not letting us confirm nominees. In fact, one of my Republican colleagues announced his intention to filibuster the NLRB nominees 6 days before their nominations were announced. 6 days before. In fact, he went on to say that an inoperable NLRB would be good for the country. Well, if that's the way they feel, offer amendments here to defund it, to do away with it, repeal the law, but then to hold up qualified nominees to carry out the law. The National Labor Relations Act is the law of the land. The National Labor Relations Board is constituted under that law to carry out its functions. And so to hold up qualified nominees because they want to change the law, again, is to try to get something done that they couldn't otherwise do through the regular order. Again, this level of obstructionism is unprecedented in the nomination process. Repealing laws by fiat is not and was never intended to be a part of the Senate's advise and consent function. A senator's dislike for a particular law or a particular agency certainly was not intended to prevent qualified and dedicated people from answering the president's call to serve their country. And again, it's the American people, not only the nominees, but the American people who suffer from these unprecedented abuses of the process. The laws that these boards and agencies and departments enforce are important laws designed to protect people. And when the system breaks down, or in this case, intentionally undermined, real people are hurt. Now, take the example of the National Labor Relations Board. They have to have a quorum of 3 members to act. If there are fewer than 3 at any time, the board cannot issue decisions and must essentially shut down. Now, the board currently has 3 members, but Chairman Pierce's term expires in August, next month. At that point, the Labor Board, National Labor Relations Board, would be unable to function unless we confirm additional members. Now, keeping the board open is vital to employees, employers, and our economy. Without the board, workers cannot seek justice if they are discharged or discriminated against for, say, talking with colleagues to improve their working conditions, or for joining or assisting a labor union, or for organizing a labor union. There are no laws out there that protect them. The only avenue available to these employees to file a grievance and to have their grievance heard and adjudicated is to file a charge with the National Labor Relations Board. Without it, they have no options at all. So if the NLRB, the National Labor Relations Board, can't function, workers effectively don't have any rights. And yet, one of my Republican colleagues said an inoperable NLRB would be good for the country. Imagine that. Leaving workers without any forum, without any recourse to have their grievances heard. Again, the same, I could also say the same is true of the Consumer Financial Protection Board. Again, it was created, as we know, part of the Dodd-Frank Act, with a simple idea in mind. Consumers deserve to have a watchdog looking out for their best interests when using financial products and services, from mortgages to credit cards to student loans to payday loans. So with the creation of the Consumer Financial Protection Bureau, consumers now have that cop on the beat looking out for their well-being. Now, Mr. Cordray, who has been chosen by the president to head this agency, has carried out his mission admirably. But if Republicans have their way, he'll never be confirmed. Never. And not only will they lose his leadership, but the ability to adequately oversee these financial services and financial products and to protect American consumers. So by refusing to confirm Mr. Cordray, and if I'm not mistaken, I believe his nomination now entered its over 500 days, if I'm not mistaken now, 500 and some days that he's been held up. So by refusing to confirm him, they're using, again, the Republicans are using this nominations process to thwart the intent of the Dodd-Frank law. And that really brings us to the point, the crux of what is going on around here that has been in the press so much lately, that we're going to have an unprecedented caucus of the Democratic senators and Republican senators out here in the old Senate chambers at 6 p.m. tonight to air these grievances. As we know, the majority leader has laid down last Thursday a number of these nominees, filed cloture on them. We'll bring them up tomorrow. If the Republicans continue to filibuster, the majority leader has made it clear his intention to change the rules of the Senate using 51 votes to provide that nominations for executive branch positions are not subject to the filibuster rule. So that's what we're talking about here. We're talking about the nullification of laws already on the books through the abuse of the Senate's power to advise and consent to nominations. Nullification. Read your history books about nullification. It was one of the issues that we fought the Civil War over. Could states nullify on their own federal laws? Well, what we're seeing here are the Republicans saying we can nullify the essence of laws or what boards are supposed to do by abusing the advise and consent clause of the Constitution. It's appalling, and something has to change. Mr. President, I first took this floor on this issue in 1995. I think I have it here someplace. Yes, here's the congressional record. January the 4th, 1995. Now, it was an interesting time. The Democrats had lost control of the Senate. Republicans were now in charge. And I, along with Senator Lieberman and Senator Pell and Senator Robb from the great state of Virginia, proposed a change in the rules that wouldn't end the filibuster, but it would keep the filibuster as it was kind of intended, as a method whereby the minority could ensure that they could amend or offer amendments on legislation. See, the right of the minority should be to be able to offer amendments, not to have them adopted, but the right to offer them and debate them thoroughly and to have them voted on. And secondly, to make sure that the filibuster could be used to slow things down, but not to be used to stop something. That's what I proposed on January the 4th of 1995. I said at the time, I basically said, if we don't change it, I said, it's getting worse. 1995, I said, it's getting worse. But I said, I believe in the long run, it'll harm the Senate and our nation if this pattern continues. And I went on to talk about the rising tide of the filibusters. I said, clearly this is a process that's out of control. 1995. We need to change the rules. We need to change the rules, however, without harming the long-standing Senate tradition of extended debate and deliberation and slowing things down. Then I went on to talk about, when I laid that amendment down, that proposed rule down, about just how dysfunctional this place was becoming. If you think it was bad in 1995, you should see what it's like now. I mean, it's just, never in my wildest dreams did I think in 1995 that 18 years later, the Senate would come to this point where we simply can't do anything unless we have 60 votes. unless you have 60 votes. We now have a system whereby 41 senators decide what we do here. Essentially, that's what they do. 41. And through the use of the filibuster, a handful of senators can really thwart the will of the Senate. 18 years later. Well, Mr. President, there's been a lot said about different nominees and what's going on here. There's been this accusation and that accusation. You got to cut through all that fog and all that haze. I referred to it in 1995 as sort of like the fog of war. Sort of like the fog of war. You got to kind of cut through it. There's only really one question that we need to ask ourselves, and the American public needs to ask themselves. Should a nominee, should a person selected by a president, any president, Democrat, Republican, I don't care, any president, should a nominee, a person selected by that president to be a part of his or her team, after thoroughly vetting, after a thorough committee hearing, after making sure there's nothing terribly wrong with this person, they meet the qualifications, and they've been thoroughly vetted, the question to be asked is, should that person have an up or down vote on the United States Senate with a majority vote? Or is it going to require 60 votes? 60 votes. Again, the Constitution of the United States very clearly points out there are only 5 times when the Senate needs a supermajority to act. You know, things like impeaching the president, expelling a member, adopting a treaty, joining a treaty, approving a treaty, things like that. And all other things, the Constitution envisions a simple majority vote. That's the real question here. There is no other real question before us. Now, Mr. President, before I yield the floor, I just want to address an issue that has come up regarding the National Labor Relations Board nominees. I want to set the record straight. I take the time to put this in the record. There have been accusations made here on the Senate floor. I shouldn't say accusations. There have been sort of stipulations, comments made that 2 of these board members are serving illegally, that they were illegally put on the board by President Obama. Now, that would be Sharon Block and Richard Griffin. Now, let's look at a little history here. They were appointed by the president in January of 2012 as a recess appointment because the Republicans would not let us vote on them. And since we needed a National Labor Relations Board to function, the president gave these 2 people a recess appointment in January of 2012. They have been serving since that time. A case was taken, the Noel Canning case, was taken to court. They were taken to court to decide whether or not the president had the authority to appoint them as recess appointees. The D.C. Circuit Court issued an opinion, and the reasoning they used was contrary to any other court reasoning in the past about recess appointments. The D.C. Circuit said that no, the president could not make those appointments, and furthermore, the president can only make a recess appointment during the intervening times from one Congress to another. No other court has ever held that. Now, there was another court that agreed that the president couldn't make these recess appointments, but they didn't go that far. They just said that what the president did was not a recess. What he did it was not in a recess. Other courts, 2nd, 9th, 11th Circuit courts, have all decided these things differently in the past. So what we have here is a decision by one court, the D.C. Circuit, taking a position that has never been taken before by any court. You have another court, the Third Circuit, that narrowly defined the president's power. Then you have all the other circuit courts that were basically all over the place on this in the past. So what happens? Now this case goes to the Supreme Court, and the Supreme Court will decide this during the 2013-2014 term. So, Sharon Block and Richard Griffin are on the NLRB. They took an oath of office to carry out their responsibilities. Now, some of my Republican friends have saying they should resign. They should get off the board because they're serving illegally. They're not serving illegally until the Supreme Court has made a final decision. I've said before, the contention of some of my friends on the Republican side is like this Alice in Wonderland, you know, first the verdict, then we have the trial. Well, I don't know what the Supreme Court will decide. Don't know. Now, we've had precedents in the past. There's a long-standing NLRB precedent when the agency faces a split in circuit court opinions. When the D.C. Circuit ruled in Laurel Bay versus NLRB that the NLRB needed 3 members to have a lawful quorum to act, again, this was contrary to the decision of other circuits, the 2-member board, consisting of Republican Peter Schomburg and Democrat Wilma Liebman, continued to issue decisions until the legal issue was finally resolved in the Supreme Court. Now, the Supreme Court said, no, they need more than 2. You got to have at least 3 people to make decisions. Now, the 2-member board, during that interim time, issued decisions in hundreds of cases after the D.C. Circuit's adverse ruling, yet not one Republican senator called on either member to resign. And so what happened? After the Supreme Court issued its decision, and the court was now had more than 3 members, the board, had more than 3 members, they went back and looked at these decisions, and if there were still open contentions, they reviewed them and issued another decision. Now, some of the decisions were accepted by both sides, and people moved on. Those that weren't were redecided by the board, including the 2 people that had served on that board during that interim period of time. So again, we have a recent precedent, and this was just within the last 5 years, if I'm not mistaken. Yes, 5 years. So we have a recent precedent that demonstrates that both Block and Griffin are acting appropriately by remaining in place, and that the NLRB is acting appropriately by continuing to issue decisions pending the resolution of this issue by the Supreme Court. They cannot and they should not resign because they took an oath of office to fulfill their duties, and they must fulfill that oath. After President Obama made these appointments, each new board member took an oath of office promising to fulfill their duties as a member of the NLRB. So I just wanted to clear that up. They are not illegal. And we await the Supreme Court's decision on this. And I have no idea how they're going to decide because there's been a split in the circuits. But as I've shown, this issue has come up before where we had a case split in circuits. 2 board members continued to issue decisions. No one here asked them to resign. And this was in the last 5 years. No one asked them to resign. But now, for some reason, my friends on the Republican side want to deny the president his choice of people to serve on the NLRB. Now 2 of those people, Ms. Block and Mr. Griffin, let's say the Supreme Court says, that the president couldn't appoint people during that recess appointment. Well, okay. We're not talking about that now. We're talking about an appointment that's going to take place right now. And he should be allowed to have who he wants, as long as they're thoroughly vetted and they're qualified. And like I said, no one has questioned their qualifications. So the president should have the right to have his NLRB board put in place now. And the question of whether or not decisions that had been made in the last year and, 5 or 6 months, those decisions, just like the ones before, in the Laurel Bay case, in the Laurel Bay case, they went back and revisited those and issued their decisions. Same thing can happen here. So don't let anyone tell you that these nominees are illegal. That is absolutely not true. People may think it's true, but it's not true. So, Mr. President, I keep hearing that, well, now there's overtures from the Republican side to make some deals, to make a deal on not having the vote tomorrow on doing away with the filibuster rule on nominations. Oh, I've heard all kinds of things floating around, this deal here and that deal there, and we've got a little deal here. Since I took the floor in 1995 as a member of the minority, I might add, to propose a change in the filibuster rules. Since that time, this issue has come up several times since 1995. Every time, there's always a deal. There's always some little deal made so we don't fix what's wrong with the Senate. We just sort of paper it over and move on. I hope that doesn't happen again. Every time a deal was made, it was papered over, things got worse. Every single time they got worse. Oh, they might have been okay for a little bit, and then we go right back into our old ways again, right back into our old ways. The old ways won't work any longer around here. They just won't. I hope that the only deal that is struck is that the Republicans agree that we all agree that any president should have his or her right to put their team in place by a majority vote of the advice and consent of the United States Senate. Thoroughly vetted, committee hearings, answering questions, yes, but an up or down vote with a majority vote in the United States Senate. That is the only deal that will get us out of this trap we find ourselves in. It's the only thing, I think, that will reassure the American people that once again the United States Senate is going to function. It's going to do its job. It's not going to be thwarted by a handful of people, or 1 or 2 or 3 or 4 people. And that we can actually move this country ahead and let this president, the next president who may be a Republican, yes, let that president have his team. I said that in 1995 as the minority. I've said it in the majority. I've said it in the minority, and I say it back again in the majority. So I hope tomorrow we finally put an end to this nonsense of the filibuster on nominations at a bare minimum. I would like to see the filibuster changed even more than that. But at a minimum, get rid of the filibuster on nominations to the executive branch. Mr. President, I yield the floor.